Testing, testing, testing. Okay. Okay, well, so the types of contract related risks, and I'll just quickly sum this up, is the business risk, legal risk, and the external risk. And you spoke a little bit about the tools that are available to us to ascertain that risk, which we'll get to. But I first want to jump into this idea that when I'm signing contracts with customers, there's often this discussion around intellectual property. So I wonder if you can walk me through the risks, the exposures, the things that we should be looking out for as CTOs as we look into those types of contracts.
Sure, yes. So there's, first of all, just intellectual property, as we know, is, things that are protected by certain laws, like copyright usually protects software, trademarks, patents. I think most people are generally familiar with those things, but we also want to talk about the kind of the buckets of those things that can exist. And there is the intellectual property that the provider brings to the table, things that are pre-existing that they create independently of this deal, even after the effective date. There's the customer IP sometimes. Sometimes they're just bringing data. Sometimes they're bringing a brand because it's a white labeled, product. There's third party IP, like if the provider uses open source or licenses in some other IP. And then there's sort of what I'll call created IP, which is now we're working to provide services and we're going to generate something in the context of this relationship. And that raises the question, who owns it and who has rights in it? And so you have this kind of, you have ownership, which is sort of like I can do whatever I want with it, or you could have a license to it. And I can craft a license that looks a lot like ownership, except for, it could be even exclusive. It could be almost equivalent to ownership. I have the exclusive right to do all of these things with this, even as to you, licensor, I can do anything. It starts to look like ownership. And so you basically say, okay, we're creating something. Should the provider retain ownership of it? That's kind of the default. If you hire an independent contractor and you just say, create these deliverables for me and I'll pay you $5, the end, the independent contractor by default owns those materials. So an employee by default, the employer owns those materials. You often have an invention assignment agreement with that employee just to be careful and sure. But with an independent contractor, you really need to make sure that that independent contractor agreement says you own the deliverables, and they're assigned as they're created to you as the customer. So those are the kind of things that we're talking about. And when you have, you can have everything from a off the shelf product where there's really not anything being created much, although you can get into data rights and we'll talk about that later, but there's not like new code being developed. And then the other end of the extreme, you could have somebody developing custom software where it's all new, or maybe mostly all new. And the bigger the customer, the more they tend to have the position that, well, I need to own deliverables. And that's not always right. And I'll give you an example. I have a lot of SaaS clients who do enterprise offerings where there's a lot of customization work to implement that offering in the organization. Maybe it's a Fortune 100 company and 40,000 of their employees are going to be using this enterprise solution, and there's just a lot of development work around that. Well, in those cases, I don't, the customer will often come to the table and say, well, we own anything created or anything that's derived from our confidential information or some variation of that they want to own the deliverables. And it's almost knee jerk. And what I tell them is, look, if we're going to create some custom configuration of your for you, we, the SaaS provider, need to own those deliverables. They're a lot more important to us than they are to you. They have no value to you independent of a subscription to our service. They're of no value to you. But if we continually sign agreements where we're handing out ownership in all these custom configurations for each customer, then our IP starts to fray at the edges, and it's not a clear sort of hey, here's our fence around our IP. We're kind of doling out in sort of often unclear ways these rights and ownership in what's basically a derivative of our offering. We configured our offering
Mm,
this way for this customer. Well, they own that configuration. What does that mean? So you want to push back on that. Conversely, there's other situations where they say, I'm commissioning you to develop an app, and it may be perfectly okay for them to own that app. That's kind of the deal, and it's understood. The challenge with it comes with whenever you do that, I'm sure just like as a lawyer, I don't, somebody says I need a customer contract, I don't whip out a clean piece of paper and start from scratch. As a software developer, you don't do that either. And so you're using a lot of pre-existing code, you're using third-party code, open source, whatever. And so the actual brand new from scratch stuff is some percentage of that end product. And so what you need to do is, in your agreements when you're doing a development work like that, is make sure that you exclude from those deliverables that the customer owns your kind of general tools, your reusable code, the things that pre-existed that you use over and over again across customers. You have to come up with a definition of that. It's often called pre-existing IP or background IP, and you want to exclude that from what you give to the customer, right? So that you hold on to that, so that that reusable tool you use all the time, you didn't just give to the customer permanently. And then what happens, what's typically done is the customer turns around and says, well, I need to know that when you this app you developed for me, I own it. I own the new stuff in it. And when I execute it, I need to know that I'm not infringing your rights in this background IP, that you didn't just sprinkle that at background IP all over my app, and then suddenly I'm infringing your IP. And so what happens is usually have a background license that says, to the extent that I've embedded my background IP in your deliverable, in your app, I grant you a background license to it. And it's
mm,
basically a covenant not to sue. It's basically saying, I'm agreeing that I won't sue you as long as you're using my background IP as part of this deliverable. You're not extracting it and exploiting it separately as its own thing. You're just trying to enjoy your rights and your ownership of your app, and I'm not going to sue you. And so that's the kind of dance that you do. You have this new stuff, you have the background stuff, you have a license to the background stuff so that they can enjoy their thing that you developed for them. And so that's all how it works when it's a custom development sort of arrangement. When it's an off the shelf thing with maybe some custom configuration, it's a totally different thing. And you just say, look, you have access to use this service. We might do some custom in configuration, but we own that. And you don't need to own anything. The only thing you own is what you bring to that gets into data rights. You bring the data you
yeah,
bring.
yeah. So I guess that would then push you sort of into the data rights thing. But this conversation around IP, yeah, is very interesting in the custom development space. And I know some questions come up around if I am outsourcing my app development, or who owns that IP. So I guess what you're saying is make sure that the contract assigns the IP to you.
Yeah, if you're a custom dev shop and then you're going to have customers, and then you're going to outsource some of your development to India to a dev team there. Is that what you're talking about? So you have like
Yes.
subcontractors or
Or,
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 or
or even
vendors.
if you're the end customer, if as CTO I'm going to outsource
Yeah.
development of a key component to India or somewhere.
Yeah, you need to make sure that it's not a default situation that you own that by virtue of just paying them to build it. You have to say that.
And so if I can, just for the sake of this conversation, you mentioned uh, the default for a contractor is that they own the IP, and the default for an employee is that they own the IP.
Yeah. It's sort of the
What I mean
default
is
that when an employee works on their customers, I mean, on their employer's business, on their employees' time, you know, using their employer's equipment, that's all owned by
the
the
company.
employer. If you're in your garage working on designing a toaster and it's on your own time and it's got nothing to do with the employer, then the employee owns that. And in fact, in California, you have to put specific statute in the invention assignment agreement, acknowledging that you're not claiming rights in stuff they make on their own time. The employee makes on their own time.
Interesting. So that is a gray area, I guess. Like if I'm coding it on the employer's laptop, employer issued laptop, outside of work hours.
Yeah, it's not definitive and it can get gray. So it's not any one of those factors. So you can't say, well, um, employee, you were, in off hours, you were developing this app that's got nothing to do with our business, but you happen to do it on the laptop we issued you. So therefore it's ours. It doesn't quite work that way. And I don't think it would, you would be able to say we own that, but and conversely, if they were working on their own laptop, but it was really, in in the employer's domain, particularly during working hours, although working hours can get really fuzzy in the tech space, what does that mean? Then it's just, would the employer, just look at it practically, would the employer expect that that's just sort of the stuff I want you to be working on for me, and therefore I own it. And in the invention assignment agreements, what you do, another thing you do is you say, you have disclosed on Exhibit B all the prior inventions you're bringing to the table, employee. And if it's none, check the none box. And so you get the employee on the record saying, like, tell me what it is now. Don't tell me when we're in the middle of a dispute that, oh, no, 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 I had developed this way before I even came to you, employer. So you want to get them on the record, and you want that none checked, preferably if that's an accurate case, or if there's something, spell it out there.
Okay, so back to
So we talk about the risks of IP. You know, we talked about kind of what all the components are and who can own what, and the risks associated with that are third party infringement. Whenever there's somebody bringing to the table existing IP or creating IP, everybody's worried about whether that infringes a third party's IP. And some areas are prone to predatory patent trolls. They're crowded with them, so everybody's worried about that. The other
is
thing
there
is,
an example of that?
so an example, patent trolls are non-practicing entities. They basically, you're familiar with that concept, patent troll?
Yes, yes.
Okay,
But
yeah,
in terms of the third party
yeah,
infringement.
right. So the client wants to know that, the provider's typically the one bringing all this IP to bear and saying, here, customer, use this stuff. So the customer is concerned that they are going to be using something that is infringing a third party because the provider wasn't careful or maybe misappropriated it or something like that. And then the customer may be the big pocket, as between, the provider's got, a tiny little business, the customer's a giant company, and the lawsuit's going to tend to gravitate towards where the money is, and they're going to go after the customer. It's a little bit less likely that the customer's going to get hit with an infringement suit when it's a SaaS product than if it's on-prem licensing where the customer is actually executing the software. but it's still a risk. And so the customer wants to know that there's an indemnity that says that the provider will cover them if the customer in fact gets sued for infringement of a third party when they
Oh.
use that offering. And that's the kind of the traditional. There's actually two ways to address infringement. You'll see in contracts. Some will say provider reps and warrants that this solution does not infringe a third party's rights. And then if that turns out to be not the case, they breached a warranty and they got to make it right. And then the way is to say, I indemnify you. I'll pay for the lawyers. I'll hire the lawyers. I'll pay for the settlement if you get sued for infringement on account of my solution. And some customers want to get both of those. But to me, that's kind of uh, double dipping. You should get one or the other, and usually preferably indemnity. So it's in other words, it's saying I'm not going to warrant that this doesn't infringe because I don't know that. It's just too complicated for me to say that this doesn't infringe my solution. But if you get sued, then I will step in and handle it through an indemnity.
So, in an example where, let's say, there's a business that runs that does sale. Let's talk about maybe a marketing automation tool or a sales tool.
Mm-hmm.
I am a I am a company that uses a startups or I am a company that uses a company X's software.
Mm-hmm.
Company X's software runs on Amazon Web Services.
Mm-hmm.
And this has become a crucial part of me earning business. And I'm using this tool, I'm paying them the subscription, but I am now have built in a dependency on this tool's availability.
Mm-hmm.
AWS, one morning we wake up and that data center is had an outage, and for a couple hours, maybe a day, this tool is offline, and this company is mad as hell, and they want some sort of compensation for what happened. Company X says, well, we run on AWS, so I mean, we
Yeah. Yeah. That
company
is.
the company's not satisfied because they're saying, oh, I don't care what you run on. I
Yeah.
trusted you for my business, my revenues, and now I've lost $500,000 in revenues because your system was out.
Right, right. And the answer is, what does a contract say? And it's very common for small providers to get caught between a rock and a hard place on their large customer and AWS, both for privacy compliance, uptime, all of those things. Because AWS is not going to give them anything. And then their customer saying, we want this and this and this. And so it really depends on the offering. You have some instances where the contract's silent to that. You have some instances where the provider is going to give SLA uptime credits to the customer, even though they know that they're at the whim of AWS. There's sometimes where it's so mission critical that they really have actual failovers into other data centers. Maybe they're on Azure and AWS, and they have an RTO and RPO of X hours, and there might be a window of downtime and a window of data loss, but it's just going to fail over to some other data center, and it's all good, but the price is going to go up. And that's what you have for mission critical things. So if you're a customer for a small provider, you got to ask those questions. And if it's that important to you, then you're not going to get that for a $60 a month service. You're just trying to squeeze blood out of the
So
small
at
providers.
that point, Company X, who created the tool,
Mhm.
um, and they sign a whale of a client, they this is where the risk mitigation or the assertions or the whatever you call that. This is where you disclose when this happens. This is we're not responsible. So typically, Company X could have said we're not responsible if AWS goes down.
Right, right,
Company customer, you carry the risk that AWS might go down.
Right. If you, in other words, hey company, my offering is priced not to have all these failovers, but to just rely on AWS. And if you had this software in house, you'd have the same risk of AWS going down if you hosted it there that
Mm.
I have. So I'm not your insurer against that. I'm not going to pay. I'm not going to cover you for that. And it is what it is. So you can take that route in the customer contract. You can be kind of silent, in which case, and there's always that question of what's down for an hour is different than hour down for a week, and at some point it becomes a breach of contract because you agreed to provide this, and it's become material enough that you're just literally not performing, and then they can sue you for breach, or you can have a specialized remedy, which is an SLA with uptime credits that says, for this amount of uptime, we're going to give you these credits. And then usually it says, but if it's just sort of ongoing outage forever, at some point it's usually a right to terminate,
Okay.
and maybe prepaid unused fees get refunded.
Okay, yeah. The SLA is pretty common. So the we're not going to get into data rights right now. We don't have enough time. So I do want to just touch again on the risks. So I think we talked a little bit about third party infringement. Can you did we talk about the misappropriation by a customer
Yeah, so
and
that's
then
just
the erosion?
right. That's just making sure you have clear statements of who owns what. And then in some instances, you have a customer who might be interested in taking your IP. Maybe they have access to the code and you're worried about them reverse engineering it, or maybe they have access to the source code or what have you. And you're just worried about, as between you, I want to make sure that you don't do things outside the scope of the license or the use rights, or you don't actually just take my code and start, just run off with it, or start developing more IP from it, or that type of thing. So that's what misappropriation is, as I think about it in that case, as between you and the customer. And
So
then
the customer might say, we've spent significant number of hours improving your product. We built scripts inside of your tool, and now they're starting to say, well, we the IP is sort of that belongs to us. Meanwhile, you might say, well, this is our tool. You created scripts inside of our tool, so it all belongs to us.
yeah, that presents an interesting use case. And I have a client like that. They've created a software platform that allows the customer to develop little mini apps within that platform for this specific use. And so now, the default is the customer would own those apps, but they're not usable outside of the license to the underlying platform. So it's kind of like that configuration ish point I made is, yeah, you develop this, but you really, you don't, it's a question of whether it's useful to the client outside of the license to the platform. And does it make sense for them to own it, or does it make sense to the provider to own it? It depends on how elaborate the app is and how much just sort of unique IP could just be in that, or is it really just associated with that platform and it's just useless outside of that? So yeah, that's a question. But the misappropriation point is more about just the customer just absconding with your IP and making sure you
Got
have
it.
clear
Okay.
language. When they're
So
starting to develop their own.
the customer saying this is our IP when basically they're stealing your IP.
Yeah, or they're using it outside the scope of their rights under the agreement. They're letting their
Okay, got
affiliates
it.
use
Got
it.
it.
They're letting more licensees using it. They're sharing passwords. They're all of that.
Okay. Okay. Okay, and then erosion of the core IP.
So that's what I was talking about with making sure that you don't grant rights in things that you develop for a customer that are custom, but that are built on top of your offering. And then the customer just says, well, I want to own anything you develop for me. You want to make sure that's not the case, because then they own these little implementations of your offering. And what does that mean? And it starts to fray the edges of your ownership. And sometimes it can be backdoored in a way that, it's not in the IP section, but in the confidentiality section, it says, we customer own anything that's derived from our confidential data that we provide you. So if that configuration involves reworking their data, their confidential information, application data into something new, then under the confidentiality provision, they could claim that they have rights and interest in what the provider developed using that customer confidential information. And that could give them something to hang their hat on and say, no, we own this. So you got to kind of look at both the confidentiality provision and the IP provisions,
Hmm.
themselves.
I one use case that comes to mind for me is sometimes when we're trying to bootstrap our companies and we pre-sell a feature. So a large customer comes in,
Mm-hmm.
they would buy your subscription if you had this feature. Well, then you say, okay, well, pay me this amount of money and we will build that feature, but we're making that feature available to everyone who subscribes on our platform.
Yep.
And that would be
Yep.
an
Like,
example of erosion, right?
yes, yes. If you don't handle it right in the agreement and say, you're paying me not for me to build this for you and hand it over to you for you to own, you're paying me to just build it and then license it to you, or provide you a subscription to it. So yeah, that's a good example of where you could really, the customer could have expectations that are not in line with what you want, because
Yeah. They
they're
might
saying,
say,
hey,
well,
I
we
wrote
need
the
a,
check. Yeah.
yeah, and I need a cut from all this subscription you're making off of my feature, my
Right.
idea.
Right. Why am I building your business for you in that way? Even though that's really what's going on anyway. If you didn't have that arrangement and you just said, we're going to use customer revenue to build this widget, that's what's happening. The customers are funding that development. It's just not in this overt way.
So let's in so the key areas of intellectual property is the background provider IP, the customer IP, third party IP, the created IP, and then the various risks associated with that. Um, One thing that comes to mind for me is a lot of times when we start, like you said, almost when you start a software project, you don't start from a blank slate. You use frameworks, you use open source tools. You use by the time you've written your first line of code, own code, you've probably incorporated hundreds of thousands of lines of code. It, as the CTO, is there a responsibility there to you talk about the different licenses for open source, the BSD license, the MIT license, the whatever licenses. Um, do you have any comments on sort of the exposure that comes with that?
Yes, it's an important area, and you know, in theory, it doesn't matter if you've licensed in private, sort of non-open source code to build your software, or it's open source. It's something that has its own restrictions, and then you are kind of incorporating that into your offering and reselling it, and you need to be doing that in compliance with whatever that third-party license is. So that's one issue, and your customer wants to know that you're doing that and you're not causing them to infringe that third-party code base or whatever. And then open source adds the additional wrinkle, which is that the license itself could be copyleft, and basically say that whenever you modify that code base, all that stuff goes into the open source library, and that obviously creates problems. But other than that, there's nothing inherently wrong with using third-party, sort of tools. Sometimes the third-party tool is kind of a module that's almost kept intact, and you'll actually address that in the agreement and say, look, anything that's a third-party tool is subject to its license terms, and you will provide those to you on request, and we will identify those in where we're going to use them, because what the customer doesn't want is to have some third-party thing buried in there that has some license and they're just not even aware it's there. So you usually have to kind of call those things out if they're going to be sort of embedded in the software, or oftentimes you have to call them out depending on the situation.
Very good. Very good. This is interesting for me in terms of protecting your intellectual property through the contracts that you make with your customers and the contracts that you make with anybody who uses your intellectual property.
Yeah,
You
and
have
I was just going to
go
say
for it.
one thing that's important to keep in mind when you're a young company and you're dealing with IP. IP is when you're young and you're just trying to get through things, and maybe you don't have solid legal counsel and you're muddling through it. There are certain mistakes that you make that you can remediate later, and there are certain ones that you can't, or that are harder to remediate. And so if you do things wrong in a way that you lose some customers or whatever, that you can get past. But if you've kind of messed up your whole IP ownership, it's hard to unring that bell later on as you get more competent counsel. And the same thing goes for each customer contract itself. If you have a right to terminate for convenience, say, and just get out of the agreement, and you have this relationship with this counterparty, if they're a pain to deal with, you can remediate that by kicking them out and terminating. But other things like bad IP provisions, terminating doesn't help you. It doesn't help you to move away from them. The damage is done. And so, as you're a younger company, you need to kind of have a sense of, this I can fix later, this I can't. I need to put
Mm,
some attention on this so that I don't erode the value of my enterprise and create lots of problems later on that I can't fix, or that are really hard to fix.
yeah, what comes to mind for me is boilerplate NDAs or non-competes, or like you 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 just you just kind of want. No one's really crafting it. It always seems like it's at the most inopportune time. We just want to get this out of the way, and then you download something from some place and you sign it and it's out there, and it's like you said, in some cases it's an innocuous contract. In other cases, there's a little clause in there and you're screwed
Yeah,
if someone chooses to litigate that.
right, right.
Well, this will be the first of many. Thank you.
Thank you.
See you soon.